Now, joining us for more on the Senzo Meyiwa Murder Trial court proceedings is Elton Hart from the University of Johannesburg's Law Clinic. Mr. Hart, good afternoon, and thank you very much for your time. Quite a lot taking place in court this week, but one would say the ruling on the inadmissibility of the alleged audio confession by Bongani Ntanzi is quite the talking point. Your views on just that ruling we heard?
No, indeed, it's a talking point, but obviously one needs to look at how was that audio acquired? And obviously, with our past of having apartheid and how people's rights were violated, it's of the essence that courts would look at how information was obtained. And the violation of your rights that's contained in the Bill of Rights is one of the most important things that courts has to always be awake to. And in this instance, what the magistrate, and I'm pretty much disappointed in how she conducted herself, because she's an officer of the court. She was supposed to know, if I'm recording this guy, I need to alert him that I'm actually recording him. And the mere fact that they want to now sneak this evidence in through the back door, it's unconstitutional. You need to, and a magistrate is not a layman that doesn't know the law. She knew the law, so she had to inform him, even if she say it was for her own personal use. Why, if it was for her personal use, maybe to just complete her forms? Why today, nearly 4 years later, she's still in possession of that audio recording, if it was for personal use? So those type of things, it's like you ask yourself, even then, if she kept it so long, what was her intention in recording this guy? Is it actually, was she working with the investigating team? Did she even see that he was tortured and she sort of half turned a blind eye to it? In the back of a normal South African's mind, these questions start toiling there, and it makes you think about a lot of things.
But we remember that the state had initially committed that they will not be utilizing the audio, so it wasn't about turn on their part. But I must say, when just listening to commentary since yesterday, many legal practitioners were a bit concerned that she is au fait with the law, and in this instance, as a magistrate, she would be a custodian of the law. So at the very least, that particular aspect of notifying the accused that you are being recorded would have been something that she would have communicated. But I'd like for us to take a few steps back to the line of questioning by Ntanzi's legal counsel, Advocate Mgomezulu, when engaging Magistrate Cronje. He took issue with the fact that the pro forma document included that Cronje was a magistrate, which the advocate says would have induced the accused into making a confession. That one, I don't know if you can enlighten us a bit here, because when you look at Section 217, subsection 1B of the Criminal Procedures Act, it basically indicates that confessing before a magistrate is not out of the ordinary. So can you just take us through that argument that the advocate was trying to put forward here?
And remember now, the advocate is a little bit with his hands in cuffs. Because remember, now the police officers is saying that this statement was made free voluntarily. So, and this guy was not sort of half tortured. But also he put to the magistrate to say, listen, yeah, this guy was tortured on 4 different occasions. And that, for me, I need Advocate Mgomezulu was just supposed to go in to say to her, if a person is suffocated with a plastic bag and he appears maybe 3 hours later before you, would you be able to see it? No, she can't, because she's legally trained. She's not medically trained. And that is the type of things that he had to just cast doubt on what she's saying, because she was working with a form there. And obviously what Advocate Mgomezulu went into is even to sort of half test her. And I could see that the magistrate is getting angry at him. And he said she mustn't be emotional. She must give the court answers. He was just supposed to test her more.
But that element of stating that just your designation would have induced the accused into making a confession, he went on to say, Advocate Mgomezulu went on to state that he would feel comfortable that he's speaking to a magistrate who has no involvement in the overall case. But I'm just trying to get clarity. Where was he going at that particular argument? If one identifies themselves as a magistrate and it's written in the document where you are now about to fill in that questionnaire, is it problematic that you are a magistrate?
No, indeed, because the Act makes provision that magistrates or justices of peace can actually take these confessions. Because obviously if you're a constable, a sergeant or a warrant officer and you take down a confession, that thing is inadmissible, somewhere from the get-go, unless a further confession is made to a magistrate or a justice of peace. So that I could not see properly, but I could see what he was trying to do. He was using tactics to get the magistrate sort of to become upset. And normally when people are upset, they don't necessarily think as to how they answer questions. And maybe you could have solicited, and that is just tricks of cross-examination. And I could not see that there was something irregular in the magistrate saying, I'm a magistrate. It actually says, okay, she informed the accused that she's a magistrate, and she also informed the accused that she's not part of the investigating team. The only thing that might be there, the trick that might lie in there for the accused person, is to say that I'm not part of the investigation. Maybe the accused now drop his guard, and then you would spill the beans and give the nitty-gritty of everything to the T. So that is maybe where I can see maybe something.
That's where he was headed.
Yeah, but with the just the mere fact that he attacked her, or he sort of tried to wrestle with her to say, you were not supposed to say to her she was supposed to say she's a magistrate. Even if it's a he must tell that I'm a magistrate, and also say that I'm not in part of the investigating team. Maybe that accused person might also come out and say, but they actually tortured me. These guys outside the door tortured me. But also them being present, being the part of the team that actually investigated the crime. They were supposed to get people that was unrelated to this investigation to actually go take him from custody and bring him to the magistrate, because accused number 2 already said that one of the SWAT members that actually took him somewhere for these, they were somehow at the arrest, and when he was taken to these various venues that he was sort of tortured. So for me, it's maybe there, but it's at this time, the part, it's 50-50. Where Ngomezulu is going, it will become apparent on Monday, because on Monday he needs to wrap up. Then one would see where does it actually slot in exactly what he wanted to get out of the magistrate.
Then the words freely and voluntarily. Much was made of their absence in that document. Take us through the importance of this particular wording, that even if one were to depose to an affidavit, that you must indicate that this was done so freely and voluntarily. How important is it?
No, that is important, because that is on which our constitution and the rights in terms of Section 35 is based on. That you have the right to remain silent, you have the right not to self-incriminate you. So if it means that these things are not freely and voluntarily made, it means that you are actually incriminating yourself and you are unduly influenced. So that freely and voluntarily, it also knocks onto the clause that you must not be unduly influenced. So these things is all captured in that right as it's set out in Section 35 of the Constitution. And to say that freely and voluntarily, it must mean that nobody sort of moved you to say, I want to tell the truth. And you must be of sound mind. Sound mind means then you need to also comprehend what you are going to now divulge to a justice of peace or a magistrate. Can land you into trouble, and this trouble can be serious, and these repercussions that can stem or flow from your making available of information or tendering, let me use that word, of tendering information, must be explained in full extent in a language that you understand. You must be able, and they did say that there was an interpreter, but I could not get from the evidence if the interpreter actually interpreted in Ntanzi's mother tongue, which is Zulu, that this is the repercussions for what you are about to do now.
And then this
so I
particular...
think they might go that way.
How much of an impact will this ruling have on the state's overall case at this point? Is all lost? Because we do know, as I stated a bit earlier, that initially they had no intention of using the audio in the first place.
No, they had no intention, but I see the reason why now the state is now sort of trying so hard to get these confessions in. Because in the confessions there is certain... and obviously, we're just now looking at the procedural aspects. Was the procedural aspects met as per Section 217 of the Criminal Procedure Act? Once that the court comes to the conclusion and say, okay, it has been met, then it's admissible. Then we would delve into what is written down in that statement. And that's what they actually need, so that they can actually now come and use that part to actually cross-examine accused number 2 and accused number 1 to say, but why did you say you were involved, and this is how Senzo Meyiwa was killed, those type of things. So to give strength to the state case. And the reason why the state is now battling so much is I think that they can see that their case as it stands now, it's a little bit on a rocky path. they can't guarantee that they will get a conviction as it stands now.
Mr. Hart, thank you very much as always for your time. That was Elton Hart from the University of Johannesburg's Law Clinic talking to us about what transpired at the Senzo Meyiwa murder trial this week.